conversation about it. We're very fortunate to have Ignacio Cofone joining us up on the big screen. Hi, Ignacio.
Hi,
And
thanks for
and
having
and
me.
oh, thank you for joining us. We really appreciate that you can join us virtually. It's so robotic and AI. It's perfect. And then in the room, we have Andrew Seltz, who's our other author on the panel, and Karis Craig is going to take us away with her amazing comments. I'll turn it over to you guys.
Thanks so much, Kristen. Let me just check that's working okay. Okay, wonderful. Well, thank you to Kristen for the invitation to be here, and congratulations. I think we're at the stage of the conference where we can say congratulations to the organisers. It's all been going wonderfully well, and it's great to see so many people still here and engaged on our second day. So I am going to preface my remarks by saying I'm not an anti-discrimination expert, and I'm not a tort law expert, and I've spent more time thinking about tort law in the last 24 hours than I did since I did a terrible DLICT exam in my undergrad in Scotland. And I say DLICT just to point out, I don't even have tort law in the jurisdiction where I was educated. So I'm going to be doing my best to share my reflections on the two papers, more from a sort of critical feminist perspective and thinking about law and technology. But I am really looking forward to handing over the discussion as well to you. So please do keep your questions and comments ready for the discussion period. And Ignacio, we've already checked, he can hear us, he can see us, and we can see him as a giant head. And so we'll be trying to integrate him as best we can into the conversation throughout. Okay.
Thank you.
So I'll start with Ignacio's paper. The object of the critical inquiry there is obviously the assumption that there is a fairness accuracy trade-off in AI. Right? So he begins by calling out as a myth the common claim that when you're implementing fairness constraints, that's going to be reducing the predictive accuracy of machine learning models. The myth is common everywhere. It's common in academia, from computer science and management to law, he says. It's common in policy circles. Google's AI regulation white paper talks about the inevitability of the trade-off. We encounter it all the time in the media and the press, which is replete with suggestions that efforts taken to minimize discrimination will necessarily reduce the accuracy of the AI models. But not so, he argues. Rather, he says there is no demonstrable trade-off between fairness and accuracy. And indeed, in some situations, fairer algorithms can actually enhance predictive performance. So he suggests that the legal and the policy community should be moving beyond what's called a false dichotomy of fairness versus accuracy, and should instead be focusing on who benefits and who loses when fairness is prioritized in design choices. The suggestion then is that the fairness accuracy trade-off is a convenient trope, right? That's what's sometimes implied and also stated at one point in the paper. For those who want to resist implementing AI fairness into their systems, so by framing fairness and accuracy as opposing values, you can kind of obscure the normative choices and the value judgments that are being made in the system design. So when we're talking about trade-offs, it's not a neutral analytical tool, but a rhetorical device, right? And one that shields decision makers who are developing or deploying systems that reinforce systemic disparities. They're purporting to prioritize accuracy, and that props up the idea of the technological sort of inevitability of the system and the way it works, and it hides then the responsibility for the harms that the system perpetuates. And so to show the falsity of the trade-off, Ignacio turns to the literature on socio-technical systems. So thinking about fair AI measures, these are usually process-based. As I understand it, they transform data sets to remove dependencies between perceived attributes like race and gender, and then target attributes like, for example, hireability. And so they're often critiqued then on the basis that when you take those measures, there's an information loss in the transformed data. And so that's what the paper sets out to do, is to sort of temper those concerns about the information loss. It does this first by looking at various definitions of fairness, some of which already incorporate accuracy into them to show that those values are not really at odds. And then also model multiplicity, which is another concept that I spent much too much time thinking about in the last few days, and not much time, obviously too little before. But the paper by Emily Black et al., and that's going to come up as well when we're talking about Andrew's paper. So the idea that there are almost always multiple possible models with equivalent accuracy for a given optimization problem. And so that means multiple models can achieve similar accuracy, but they would differ in how they treat different groups, right? So creating that capacity then to address fairness concerns without sacrificing accuracy. So that's looking at sort of tempering the idea of a trade-off. But it goes further then in the paper to say the trade-off is a myth. And here it's about emphasizing that the output variables themselves are only proxies for the ideal characteristics or the qualities that the AI is designed to uncover. So that the idea of proxy bias applies not just to the categorization of data and algorithmic labels in the data set, but also to the output variables, because even these stand in for normative facts. So the example is that similarity to past hires, for example, in a hiring model, is only ever going to be a proxy for the qualities that might make a promising employee. And even that, of course, is only going to be a proxy for trying to determine whether this particular person will in the future be a good employee. So you already have everything standing in as proxies for other facts at the output end. And this matters because the choice then of output variable isn't about objective accuracy at all, or about getting close to any kind of ground truth, but is itself a socio-technical, ethical decision that has implications, again, for who benefits and for who is harmed. These also reflect then biases of system designers. Okay, so what this means is that without correction, AI systems can actually spiral away from their intended objectives. They can entrench biases, they can entrench inaccurate decision-making criterion. And so this is where in the portion that overlaps with the next paper, the suggestion is that algorithmic discrimination is mostly a disparate impact problem. And that means that fairness constraints actually should be required for AI in areas like housing and employment and financial services, because there's an obligation to use less discriminatory alternatives if they are comparably effective. And so that's where the rubber hits the road in terms of the legal analysis and bringing it together with the technical analysis, right? If the fairness accuracy trade-off is false, then there is no business justification for not imposing fairness constraints. But he also notes that for disparate impact, as opposed to disparate treatment, you'll correct me if I'm wrong about this, discrimination claims, then some degree of reduced overall accuracy could be an acceptable cost. But you can actually have an acceptable cost to avoid disparate impact claims, and maybe then overall accuracy could be something that we're willing to sacrifice to remedy that kind of discrimination. Okay, so the paper does find a trade-off to be possible in certain very limited circumstances. That's where accuracy isn't already built into fairness metrics, and the output variable is closely tied to a relevant ground truth, and the output variable isn't itself biased. And only in those circumstances might increasing fairness mean reducing predictive performance. The example given there is AI models for skin cancer detection. And so he concludes anyway that we have to get beyond the myth that AI fairness and accuracy is a blanket trade-off. So long as it persists, the myth, then policy concerns about the costs of requiring fairness are going to be overblown, and the ethical aspects of how algorithms are deployed, how output variables align with social values or not, are going to be overlooked. Okay, so that's the sort of summary, and I very much appreciate the idea and the focus of the paper, and it really did as well, I think, help me to break down various aspects of the perceived fairness problem in AI systems. So I find that all very helpful, assuming that what I've said is actually right. If everything I said was nonsense, then the paper is not at all helpful, and I clearly didn't understand it. Okay, good. So soldiering on, I will admit, as you can probably tell, there were parts of the paper that were a little bit too dense to me. There were lots of sentences that I had to read and reread, and it may or may not be because I was on Via Rail 1 and they give you free wine. So I also not sure I can blame Ignacio for that. But 2 glasses in, I wasn't quite sure what was going up and what was going down. Anyway, I will say that I found I was confused somewhere along the line of going backwards and forwards between saying that the trade-off is a myth to saying that it's overstated and should be tempered and doesn't always apply, but sometimes applies and then it's a myth again. And I find myself thinking, you know, well, which is it? And then also if we're saying that it's a false dichotomy, going from saying, okay, this is a false dichotomy to then talking about, well, you need to prioritize, we could be prioritizing fairness over accuracy. And that again suggests to me that there's kind of a prioritization, which in turn implies a kind of zero sum, one up, one down, which one has to go first. So I found that maybe just in the framing of those issues, there wasn't consistency throughout, or maybe the narrative that you're trying to get to where you go from casting doubt to refuting it entirely isn't particularly clear because of where you end up. But it felt like it was a little bit inconsistent in that. I also, when it came to the counter, well, I wonder if then perhaps it's too much to call it a myth. You end up kind of undermining the claim that it's a myth a little bit, and then that might feel like it's an overstatement, which might actually weaken the claims that you are making and substantiating. As for the counterexample, the way in which fairness can improve accuracy, where the output variables are all noisy and biased, you were suggesting that actually the fairness correction makes it more predictably accurate. I think that's a really interesting and important insight, and it was kind of buried in the analysis behind some of the technicalities about output variables and so on. So I'd like to see that brought forward a little bit. And I also wanted a little bit more willingness to acknowledge the so what piece, right? Like the bit that even when there is a trade-off, the reason why we might prefer fairness to accuracy if it is zero sum in certain contexts is, I don't know, like fundamental human rights, equality, things that matter to us. And so there's something about the way that you're trying to back away from saying, well, there might be costs that have to be borne by decision makers. There might be, you know, limits on predictive accuracy that have to be enforced because fairness is the priority concern. If you're if you want to say it is a priority, but also don't worry, then you have to, like, in terms of positioning the paper, you want to bring along the people who object to making compromises in the name of fairness, but you don't want to lose the people who think that fairness should be the prevailing concern. Right? So maybe a just more full-throated defense of the importance of fairness to accuracy in certain contexts. And then I just thought the medical example at the end is a place where you say, okay, this is a place where there is or would be a trade-off. It fits my model for requiring a trade-off or for there being a trade-off, and one that we wouldn't want to make. Right? So that's the medical, the skin cancer detection example. It seemed a little bit too easy, a little too trite. We haven't lost him, we've just lost his giant face, is that right? Okay, so you can still hear me. Okay, he's back. You're back. But yeah, I think that the like it felt like a little bit too easy because of course everyone's going to say yes, we don't want to have any loss in accuracy if we're doing something as important as predicting like cancerous lesions, right? But are there other examples where they would it would meet your qualifying criteria? There is an actual trade-off, and you want to say, but still. You must trade it off, right? We still want you to trade off. And are there medical examples where we would be particularly worried about a loss in accuracy, but the analysis would say, like, you're going to say, oh, no, don't worry about it. There's not really a trade-off. And people would be very uncomfortable with that conclusion. You know, I think that you could use examples that test your theory a little more rather than just shoring it up. But the biggest point here is just the sort of framing issue, I think. I found often there was a lot of technical details, and then I get to an example that I recognized that resonated and I understood, and then I would have to sort of go back again and read the technical descriptions to make sense of that. And so I would suggest maybe turning that around and trying to do the compelling examples and the framing, the political points first, and then conducting or demonstrating through the technical discussion why your argument holds. That makes sense. So those are my comments with regard to Ignacio. And the way we're doing it, I think, is I just forge ahead with the others before I pass it over. Okay, so over to Andrew. Your paper, Artificial Intelligence and the Discrimination Injury. Right. What was it called? Okay, but I did read it. And it was after I got off the train, had a coffee. I'm on it. Okay. So the focus of Andrew's paper is similarly about the ways in which AI systems produce unfair results, specifically discriminatory results, and then the limits or the capacity on the capacity of the law now to respond to that. More specifically, for the law to appropriately assign liability for those discriminatory impacts and outcomes on really the developers of the AI systems, where he thinks the liability belongs. So the paper takes up as its object of critical inquiry the suggestion that existing discrimination law in the US can apply in the US or easily adapt to apply to AI discrimination. My biggest point is it's mostly by the US. I'll get there. And so to the contrary, Andrew argues the core conceptual foundations of modern discrimination law render it inapt and incapable of adequately addressing discrimination. So the first problem he identifies is the so-called tortification of discrimination law. Right? So rather than being a broad public policy concern that's aimed at sort of rectifying inequality in society as a whole, as experienced by subjugated classes of persons, discrimination law has come to be, since the 1990s, essentially categorized as a species of tort in the US, and so focused on the redress of specific injuries or harms caused to specific parties by specific decision makers. So in other words, its focus has been individualized in a way that prevents it from really seeing and certainly capturing the broader harms experienced by groups of people as a consequence of the kind of upstream decisions made by AI developers. Looking for that individual responsibility, the individual injury, and that being on an individual plaintiff, that's the kind of atomistic analysis that fails to recognize those larger patterns. The second problem is in the challenge that's involved in articulating a specific injury that discrimination visits on its victims. So the difficulty is in the law's ability to capture and define what that harm of discrimination is, separate from a particular deprivation that was visited in them. They didn't get a job, they lost a job, they didn't get a house. But what is the harm of discrimination itself? So the reduction again to the specific deprivation prevents law from recognizing structural institutional harms in general. So in the AI context, even if it can be shown that an AI system produces a disparate impact on people in a protected class, these features of discrimination law are going to make it hard to get at that injury, right? One, because courts are likely to attribute liability to an ultimate decision maker. They've got a sort of fault-based analysis. They're looking for an ultimate decision maker. But that person might just be using an AI tool, assuming it makes fair decisions, not knowing how it works anyway. And so the court's going to be reluctant to hold that person liable. And then the AI developer is the most appropriate person on whom liability should be placed, the cheapest cost avoider in the economic model. But they're likely too far removed from the decision that actually visits the discriminatory harm on the particular individual. And so the paper works through the possibilities of applying disparate impact doctrine to AI discrimination, talks a lot about model multiplicity, the availability of less discriminatory alternatives and so on, but continues to find difficulties in assigning liability where it should go. Things like blameworthiness, remoteness, the lack of technical expertise of a court, the relative responsibility between various or multiple parties, all makes it unlikely that discrimination law is going to provide the tools that we need to address the harms that we see. So having recognized the limits on that tool, Andrew proposes turning instead to other forms of regulation to address and enforce the responsibilities of AI developers. so seeing the harm of discrimination separately from the decision of the decision maker reveals those alternative regulatory approaches. That's to say, turning then to consumer protection regulations or legislation that could address group harms might be the answer. Or product safety approaches, something like the EU AI Act and its risk management strategies. Or a product liability regime, which requires an injury but escapes the problems of individual blameworthiness. All of these have some promise, but all of them have some limits as well, and that's where he leaves us. So I was going to say, in terms of just some comments on this before we open things up. The claim at the outset is that you're not going to get into the doctrinal and technical weeds of tort law, and you're going to take a step back and examine the conceptual foundations as well. And I was excited about that. And then I was like dragged kicking and screaming through the doctrinal and technical weeds of tort law.
Okay, I said I'm not going to get in the doctrinal weeds of discrimination law.
Oh, okay. Well, there's.
I probably did that too.
Right? Yeah, you did that too. You definitely did that too. Anyway, there were some weeds, and I was in them. No, it's very good. It's a long paper, right? And it ends up being a very thorough review of the two different areas of law and a lot of pulling them together. So a huge amount of work and a very, I'm going to say, like a fully sort of formed paper as well. Like it feels like it's ready to go. You spent a lot of time thinking about it, and all of the arguments are very much nailed down. I did wonder in the end if now you might want to go back and sort of extricate portions of the paper from the weeds, because it seemed a bit like it was a journey for yourself to respond to arguments that had been made. Well, what about this and what about that? And then you go there, and then what you do in the end for each one of these sort of pieces is you come back from it saying, no, actually, I think I'm still right. This is still a problem, right? So maybe we don't need quite the same degree of a detour if ultimately the point is, no matter, using the model multiplicity arguments, using disparate impact arguments, at the end of the day, you're still saying, if courts regard disparate impact as fault-based, if they stick to their standard process injury model, then you're not going to be able to reach the developers upstream of the decision makers. By the same token, I wondered if you devoted too little time to the regulatory alternatives piece and unpacking their corresponding limitations. So, I mean, you do identify what those are, the sort of potential unworkability or ineffectiveness of the EU AI Act approach and the box checking compliance models, the limited concept of danger or harm that would ground any proposed solution in products liability law, and so on. And so there's definitely more, but I understand that that's you proposing something that might come out of recognizing that discrimination law doesn't hold the answers. I wondered why not give a little bit more conclusory force to an argument that tort law is then the problem. Like there's a problem with discrimination law, and rather than just turning and saying, well, that's not going to work, to something else, that there should actually be, again, a more sort of full-throated critique of the direction in which US discrimination law has evolved to fail to address structural and systemic harms in the current age. Might this be like a call to arms to change the direction of discrimination law? Because it really has to be a much more effective vehicle to address and redress social subordination at large, that we've seen that to be the case. And it's also become an obstacle to like affirmative action projects that try to ameliorate the position of subordinated minority communities. So it has much bigger problems beyond the AI context. And it seems arguably just a little too easy to say, well, I'm trying to fix the AI problem, so I'm going to put this aside and turn to something else. I also wondered if a tort law scholar, which again, I very much am not, might suggest that the individualized atomistic nature of tort law that you present actually misses or overlooks a larger distributive justice theory and social normativity that historically pervaded tort law and that should inform the analysis of individual tort claims. That this might be a bit of a sort of US phenomenon that has more to do with US legal framing than with a necessary quality of tort law. And here I thought that's why I'm suggesting maybe looking to England and looking to Canada and asking if tort law exhibits maybe a greater focus on distributional justice and social harms, and diverges then from that more traditional corrective justice approach. Is there a way to strengthen an argument for better discrimination law that resists individualization in the way that you address, that actually is more robust as an anti-subordination tool? And then I also wanted just to note that, and this is where, again, the point is this is about American law. And I'm not saying that you need to be a comparativist here. It's just that, you know, as I understand it, correct me if I'm wrong, Canadians who know and understand tort law, but in Canada, the Supreme Court preemptively ended the development of a common law tort of discrimination. It just said there's no such thing. The reason is we have Human Rights Act, we have human rights codes. You go to the tribunals, you make your discrimination claims there. You're not getting a tort as well, right? And then the idea was that there you have to show that there is a public interest element. It's not just a personal injury. So it situates the individual harm in the context of the public interest, but it creates gaps then in terms of individual remedies. And also it's not a great system. And guess what? It doesn't actually work really well. And so the other point might just be to say that if that's the case, if you've got other jurisdictions that didn't go down the tortification of discrimination route, but have the same shortcomings with regard to the problem you're trying to solve, AI discrimination, then maybe this whole tortification thing isn't the problem with discrimination law. And so it kind of like, I think it might just force your hand a little bit to think about what the alternatives would be. I know I've gone on, so I'll leave that there. I've got one common point for both papers, and I think this will draw it back together again and open up the discussion. So the common point is that both papers kind of identify a problem and then propose a solution through some sort of alternative framing device in a way that's helpful, but that perhaps is still not acknowledging the even larger patterns and problems and foundations that are responsible for the ill that you've identified. So for Ignacio's paper, there's this fairness accuracy trade-off. It's less a technical fact than it is, as you show, a manifestation of an old trope, right? That we can care about your equality concerns, but then the outcome's going to be worse, right? So it's not really technology as such. We do the same for EDI hires. Oh, you could hire using equity and diversity and inclusion, but they're going to be less skilled employees. And so this kind of notion of a trade-off is a bigger problem than the technical issue that your paper addresses. Really, the trade-off, nobody really thinks it's the technical truth. Talking about the trade-off is about sustaining a status quo where the reality is social subordination. That's actually the point. For Andrew, you talk about individualization, atomism of discrimination law analysis, and I've suggested, you know, this is part of tort law theory, but it's not an accident of tort law theory, and it's not only in tort law theory. It's actually a fundamental feature of the liberal frame and the neoliberal frame of modern legal systems. It's how the law works, is to disregard patterns of social subordination and inequality behind a myth of individuality and individual equality across the board. So you could get out of tort law and turn to any other area of law, and you're going to run yourself aground on the same problems because these are problems of the law. And so I wondered, I was thinking about Kristen's point yesterday, that this isn't, we're talking about technological problems. I'm talking about technological solutions, but the actual problems are social solutions and problems with the way that the law responds to social harms. And to Woody's point and paper as well, I think, you know, turning to doctrinal play and legal or technical solutionism, you're going to end up with these half measures and tinkering at the edges. Are we really mounting the full throttled argument against discriminatory practices in AI and beyond that we could? Are we really trying to say, like, the law has always failed to address these harms, and now is the time, as they're being compounded by technology, that we really must go back to those first principles and address them properly? Okay, sorry, that took a long time, but it's 29 minutes, and Teresa yesterday was 30, so she had 3 papers, admittedly, but Andrew's was very long. So, so anyway, with that, I'm going to open the floor. I don't know if anyone wants to respond first, and you can. Yeah. So do I have to do something for Ignacio? He's ready to talk. Okay, so on you go.
I don't have much to say other than
Okay.
thank you so much for the comments. They're really helpful. I've been writing them down. I'll work on them when editing the paper. The only thing that I would add maybe is that one thing that I was thinking that I'd like to do with the paper later on that I didn't get to because of the finishing things for the deadline is separate the argument in a strong form argument about the trade-off and a weak form argument about the trade-off. The strong form argument being accuracy and fairness are always at a trade-off, and the weak form argument being accuracy and fairness are a trade-off in this particular case or in this particular way. And I think the strong form argument is a myth. The weak form argument may or may not apply. I think people overstate it, but it's not necessarily a myth because it could be more true or less true in different circumstances. And I think that may that may answer part of the things that you correctly identified being a bit of a back and forth in the current draft. And other than that, I mean, nothing to reply other than thank you so much for engaging with it so substantively, and it was really helpful.
Great, thank you.
Okay. Yeah, I also say thanks, Karis. I do have a couple things to say. I wanted to make one clarifying point about the paper's argument, and then I'll maybe respond to a couple things. The one clarifying thing I think is that I'm treating the question of whether discrimination law is effective on its own terms as a separate. It's a very separate point from whether it can get to the ultimate developers, right? So discrimination law on its own terms is targeted at the ultimate decision makers, right? The people who choose whether a job is being handed out or not. And there's been a lot of debate, I mean, that I've been doing a lot of in the last 10 years about whether that's gonna, work with AI. And I actually think it does depend on how much ultimately it's even disparate impact is seen as fault-based versus strict liability. But that's, pretty somewhat standard discrimination kind of claim. My second claim here is because of the way the discrimination injury is structured, that atomistic moment of decision that is, and that's where we see the discrimination harm occur, such that if it's not in that moment of decision, there is no discrimination harm, not just that there's no liability, then conceptually it's very, very difficult to even amend the law to bring in a developer, to bring in someone that is not the ultimate decision maker for discrimination. And so those are slightly separate points that I want to make that both sort of result from the fact that discrimination has been tortified and nobody knows what the injury that tort rectifies is. Okay, so just wanted to clarify that. But yeah, I mean, I really appreciate the comments. A few of the comments were like, why am I not addressing the sort of like bigger picture issue when this is obviously like such a stupid way to do things? And it's just like, I completely agree, but there's an element of like, I wanted, like, so this came out of something that's been bugging me for, I don't know, 10 years since I originally started writing about this, and thinking that there is a deeper issue than just the statistical sort of doctrinal stuff that we've talked about why discrimination law may or may not work, that's inherently conceptual. And it's because and so I wanted to start from the point that our concept of discrimination is broken in certain ways, and say what are the implications of that for what we're trying to do with AI. I agree completely that tortification is a problem. I don't know that I agree that it's a problem of law in general, not just torts. I mean, I think that's a sort of more of a critical theory point, which I do agree with, but it's a different kind of point than a more doctrinal point, which is that because it's become a tort, it has a certain shape. Whereas if we had a better world that would more likely consider, disparate harms, it would have also resulted in a better version of discrimination doctrine. And I'm just critiquing doctrine, you're critiquing the world. I agree completely, but it's a different claim. But anyway, yeah, so, and then on this being a US paper, I'm guilty, like absolutely. And I think you mentioned human rights, and I think that's a big difference between the US and basically everywhere else that I might think of as talking about discrimination law, right? Like it's one of these things where you're in the space, and I mean, I fail at this all the time of thinking about non-US context when I'm writing about US law, and I should do more of that. But discrimination feels like one of those where it's like, it really doesn't translate. Like, it's very hard. We have ideas of, the disparate treatment, disparate impact, or direct and indirect discrimination that don't perfectly map between jurisdictions, and the ideas are there. And like, ultimately, yeah, so guilty as charged, very US-centric paper. I would love to think about a little bit more even as a comparative, like what do other countries do? Can I pull from that and be informed from that? So I will try to look into that a little bit. But yeah, so I really appreciate the comments, and I look forward to the rest of your questions.
Right, I'll invite you up to the microphone.
Hi, Vasanthi from Windsor Law. Since you gave the disclaimer of the US-centric, figure out a way to broach this better. But the UN Special Rapporteur, I know America doesn't care for UN Special Rapporteurs, but it so happens to be a UN Special Rapporteur on racial discrimination, who her whole focus has been on algorithmic discrimination. And she's done this report on how it has been addressed across multiple jurisdictions. But I sense that that's not of much importance for a US-centric paper, but certainly has a lot of examples to use, as well as jurisdictional differences in how discrimination has been taken into account, AI discrimination. So with respect to Ignacio's paper, and perhaps even with yours, one of the examples I was thinking of is in healthcare, and you must have read about the, I think it's called VBAC predictor, which is the vaginal birth after cesarean predictor that was used to basically make decisions, AI decisions, on whether women should, whether a woman should have a vaginal birth or a cesarean, because it's kind of like a chance decision that's made. Anyway, so the earlier algorithm, before it got, just hue and cry as to the impact that it had race as one of the predictive factors. And what that ended up doing was that African American women ended up being prescribed far more cesarean births than vaginal births, but it was based on the data which shows that the reason why you have higher maternal mortality amongst African women is not because of, it's because of social factors. So anyway, so what they did in, I think, last year, they removed race from the predictive factor, and they made hypertension the predictive factor, so which kind of corrected for fairness, accuracy maybe? Accuracy. I'm very confused between, so it corrected for accuracy. But I think the problem goes back to what you raised. The problem was not necessarily the problem with the data that was being trained or anything like that. It was because the health sector is just incredibly racist. Even the way the doctors are told in terms of how to decide on these decisions. Like, a doctor would have made the same decisions likely, because they have been trained to look at that race data in that fashion. Another example is to do with kidney disease. So they use is EGFR, which is a number that's being generated by the health sector to decide, and that's also, that itself is racialized. It predicts kidney problems among African Americans wrongly. So what we then have is that you can use all the health data that you want, but you have this issue that you're simply, you have a problem in the way healthcare has worked against African Americans, and in Canada against Black Canadians and Indigenous people to begin with. So it's not even at a place that the AI cannot, it's not even a question of a trade-off, I feel. Like, you just don't have the data that is clear. It's not that it can be corrected by increasing the number of, increasing the data of African Americans or Black Canadians or Indigenous Canadians, but just the way in which this knowledge has been structured in healthcare. So I don't know how that example work. The reason why I picked this up because you had the dermatology example. So I thought like, okay, a more interesting one would be on cesarean operations because that has had such a big real world impact on not just Black African Americans, but also across the world because that's a factor that's used in Africa. It's used by health organizations, by WHO all over the world. So it seems to be far more impactful.
Yeah, thank you. I'll look into those. I look into those to give a more detailed and informed opinion later. But I think from what you're saying, one of the things that these examples show is that we should not be so afraid of applying fairness constraints. Like if it is the case that a certain AI system leads more Black women to C-sections that it should, because historically doctors have led more Black women to C-sections that they should, then making the system less predictive with regards to the output variable of would this woman have been led to a C-section by a doctor? Maybe it's not so bad. Maybe it is correcting for historical inequalities. Some of these examples are hard because we have no counterfactual. For things like lending, there is in the end a ground truth at the end that we can test the algorithms for but for things like C-sections or kidneys, that becomes a lot harder, and then you do have some inevitable level of uncertainty about whether the decision was correct or the decision was incorrect. But I'll look into them and yeah, I think they could be really helpful to strengthen the point.
Awesome. Thank you so much. Yeah, I love this topic. And I just want to give a big +1 to something that Kara said, which was in comment on your paper, Andrew, and about the relevance of the comparison with Canada as but one jurisdiction that can possibly be relevant here. And I'm not saying it's for this paper by any, I'm not coming here and being like, write a different paper. Instead, I'm saying there's another paper here. But I think that observation is so poignant and helpful to possibly both of our jurisdictions, which is the point that in Canada, we don't have a tort of discrimination because it was overtly shut down because there are these other avenues. And it is recognized amongst folks who work in tort law, especially those who are concerned with, social oppression, that leaves a gap. And so in a jurisdiction where there's no tort of discrimination and there's a lot of concern, and I wouldn't dare say consensus, but I would say consensus from a group of people at least, that is a serious weakness, is really interesting to hear that there's a problem in the United States that discrimination law has turned too heavily to tort. And I think part of the issue here goes to Karis's point about the bigger picture, which is relevant to the doctrine, to the doctrinal analysis, which is that the reason that there was no tort in Canada that was recognized, like that it was overturned by the Supreme Court, was because there's this option to go to human rights tribunals that are chronically underfunded, that are not provided with legal jurisdiction to remedy all forms of discrimination, only a targeted type, like set of discriminations. So for example, discrimination on the basis of class is not, you can't litigate if you've faced discrimination on the basis of being homeless, for example. And so there's a consideration that maybe tort with its potentially large damages could have that normative impact of threatening organizations that are only concerned with profit into being more mindful of the ways in which they might discriminate on a very limited, only individualistically analyzed basis. I mean, our tort law suffers the same limitations of being very atomized. But I think there's something to be said in this comparison that maybe, again, not that it like goes into this paper, but I think contextualizes maybe the points that you're making in your paper. That is it a problem that it's gone to tort, or is it the underlying groundwork that is actually the problem? Because we would be like loving a tort opportunity here, and that's not available. And so there's those similar concerns.
Yeah, I mean, I appreciate that. I mean, it's definitely interesting to hear that perspective from about the Canadian law, about how it feels like there's a tort that's missing, and
it's not universal by any means, but there are folks who would
Yeah.
argue on behalf of that tort.
Yeah, and I'll say I think most people who think about discrimination law in the U.S., like on the scholarship side, decry the tort framing as well, right? Say like this is not what it was supposed to be, and when it started out, it's they tried to thread this needle between both a distributive justice and corrective justice angle, and the Supreme Court has been. I mean, if you take a step back, right, and take a critical approach, it's like tort was one way of hollowing it out,
Yeah.
right? And like whatever way they could find to hollow it out, they do it, right? And like in the U.S. it's tort, and in Canada it's something else,
Chronic underfunding. Yeah.
right? And like it's not just tort, but it's like a very narrow idea of what tort can accomplish, without calling it tort, because then you start to also think of it, okay, like let's have more robust tort doctrine. No, we're not going to call it that. We're just going to invent things. So like,
yeah,
there's all the problems, and it is certainly interesting from like a comparative perspective how discrimination as a concept has been decimated differently.
Like to that
yeah.
point that legal systems maybe just don't actually want to remedy discrimination. Like there can be social pressure to create some mechanisms, but that's not that the collective interest is to eliminate discrimination.
Yeah, and I mean we could also start asking questions about the difference between discrimination as a concept and like anti-racism,
Yeah.
right? Or things like that, or full equality or equity, or all these concepts that are related but not identical.
Yeah.
And what work is discrimination as a legal concept doing, as that's different from those others. And there might be a justification, at least I understand why it has a place in law that can't that if we could say that even the ideal form of discrimination does have a place in law that maybe isn't the exact same as rectifying all historical racism, because that is not what discrimination as a body of law does. But I don't think everybody agrees on what that would even be. I mean, so part of the difficulty in finding an injury is because nobody agrees on the normative purpose of discrimination law, because very few people have actually stopped to define it. We just sort of said this, there's this thing, we shouldn't do it, and we're going to create a body of law, and like, then it happens, right? And it's, it's a relatively new body of law as far as these things go, right? Kind of as a body of law, it only started in like the 60s as like a recognized thing. And so on the grand scale, it hasn't been sort of well theorized and well fleshed out as to what the body of law even is doing. And so a lot of these are pretty fundamental questions that I don't know if I'm actually equipped to do all of them or much of them, but I'm a little AI piece. I can maybe help.
Yeah, well, and I mean, obviously, like the different social histories of Canada and the United States are relevant to how those jurisdictions have evolved to different conclusions as well. But I just think, yeah, +1 to Karis's point. I think there's something meaty there.
Ignacio, I wanted to briefly comment on some similarities between your paper's kind of core argument and some more mathematical interpretations of the same kind of topics. It sounds like what you're really arguing for, from a math perspective, is that fairness objectives can be used as a type of regularization, as a way to prevent overfitting to given data and to the training data that we have historically, right, which has these biases. So how do we eliminate bias in training data? We do so by assuming a model and then regularizing our model, regularizing our predictions towards that model. And we do so, and the way we do so in neural nets is very complicated, and it's called implicit regularization. But what you're arguing is for, I think, a kind of form of explicit regularization in the form of pursuing fairness as an objective under the presumption that a fair model is going to perform okay, and therefore having more fairness is going to help us with an underlying objective that we can't actually train for, and that otherwise we would overfit past by looking at just historical data. Thought that might be an interesting kind of mathematical perspective that would fit into your paper, and happy to chat more after.
Oh, thank you. Yes, it is. And I'd love to chat more after. I'm going to look into this. But yeah, if I could. Sorry, I didn't get your name, and I only see Andrew in the camera.
Sorry, I forgot to give my name. Parth Noble from Stanford.
Oh, great. Thank you. Yeah, if it's okay to email you, I'd love to chat more about this. Yeah,
definitely.
Thanks.
Hi, Vance Riggs from Northeastern. So every so often you'll read articles. I'm thinking of one by Zoe Samudzi about 7 years ago. It was called Facial Recognition Systems Are Terrible at Recognizing Black Faces. Let's keep it that way. And her argument was there's no way in our carceral system that, first of all, you could get extra data to make the models more accurate without more surveillance of black faces. And second, that once you had that, inevitably it would be used in carceral ways against black populations. I've seen similar literature about so-called gaydar systems that purport to be able to look at someone's face and read off what their sexual orientation is. And again, the argument is, we can argue about the fairness of the model or the accuracy of the model, but ultimately, all of that's ancillary to the larger social context in which the model would be deployed. And so in a way, that discussion is a sort of waste of time, or that's even a sort of waste of time as a goal to pursue. So I wondered whether either of you found in your papers maybe resources that could help someone on either side of that argument, or maybe there's multiple sides of the argument. Just in terms of thinking about when is discrimination in itself a bad thing or a thing to seek to eliminate from a model, as opposed to the larger context in which it's going to be used? To what extent might making a model more accurate make it actually worse for society or for some people in society? Thanks.
Oh no, I mean, just thanks. I have thought about that in the past, in past projects. I have not with respect to this project. So I'm curious. I'll have to think about what that, like, if that means, like, what that means for the current projects.
Yeah, I think maybe this is a higher order question than the ones that we've been approaching, and it's like, how is the AI model being used? Is the AI model being used as a tool for oppression, or is the AI model being used as a way to determine the deservedness of someone for a certain result, and then we do want the most fair and maybe even the most accurate result possible. And I think in those cases where there's a decision-making process where you're seeing whether someone deserves something, and that could be a zero-sum game, like there's certain number of slots for hiring, or a non-zero-sum game, like what's your risk score to determine whether you get bail or parole, then you do need to tease out the deservedness. But then there's a higher order question, which is, when do we use an AI system at all? And that's the example of facial recognition is great for that, because there could be situations where we just don't want to use facial recognition, and making facial recognition more fair in that sense doesn't make a lot of sense. I think one of the problems with a lot of the discourse on facial recognition has been focusing on the inaccuracy of facial recognition. And it is true that the inaccuracy of facial recognition causes lots of very real harms, like false arrests. But that can sometimes obscure that the accuracy of facial recognition can also produce lots of harms. And in a system like that, I think it's important to keep both in mind. And as you said, accuracy is not necessarily something socially desirable to take uncritically and implement the system everywhere.
Great, thank you. Okay.
Hi, so he can't see us, right? So
Turn around.
oh, okay, hi
Sorry.
guys, so it's Cynthia Koo.
Hi.
Oh, no,
Hi.
it's okay. Actually, so just to riff off what Vance said, I think he's speaking to the idea of predatory inclusion, which Tressie McMillan Cottom has written about, and that tends to be my go-to response for people who are like, oh, we'll solve facial recognition bias by just getting everybody's data. But you're right, that can actually make things worse. And because it's like, okay, you are technically being more inclusive, but it's for a predatory purpose where the tech is still going to be used against the person anyway. So it's kind of both are bad. Like, it's bad if it's biased, and also still bad if it's accurate.
Yeah.
And then this, I was going to say, Andrew, I haven't read your paper yet, which might have questions, but I'm very excited to read it. I always love when you have a new paper out, so hopefully keep writing about this for a while. And it was really cool because it's like there's been the line of discrimination papers and the line of negligence and tort papers, and then now this kind of merges them. And then Vance's question actually was the perfect setup for what I actually came up here to comment on Ignacio's paper, which is, so I actually really like your paper. I don't have any notes on the paper itself, but I'm wondering if you wanted to add a more extreme layer to it, it almost is, so the argument you make is that even taking everything you say and saying it's right, which I agree with, I almost wonder if it's still a trap, if focusing on fairness, even focusing on fairness correctly, is still a trap, even more first order, like a zero order trap, because okay, so if you look at it from the perspective of substantive equality in Canadian law, which is, it's not just for, like, algorithms are kind of like a pure essence of formal equality, right? And substantive equality means you treat different groups differently in order to achieve equity at the end of the day. So with a focus on fairness, I guess to put it really bluntly, it feels like after 500 years of arresting and imprisoning too many Black and Indigenous people, focusing on fairness now really is just focusing on making sure we never ever arrest and imprison too many white people. Whereas it seems like true substantive equality, again, provocations minded, we could have an algorithm that is unfair towards white people and implement that for the next 500 years, and we would still be fair historically speaking, right? Like we wouldn't have to worry about true substantive fairness until that point. And so that makes me wonder, like, because of how we got to where we are today, everything is kind of already rigged, like the playing field is already not level. And so just this obsession with fairness in the first place already itself seems kind of unfair.
Right. Yeah. Oh, that's a great point. Thank you. And you're also giving me a perfect runway to make a question to Andrew's paper, which I really enjoyed. And he thoroughly persuaded me about the certification of US anti-discrimination law. So there are two papers that I really like from the late 80s by John Gardner, asking whether anti-discrimination law is an issue of corrective justice or distributive justice, to the extent that we believe that that's a clean distinction and it doesn't have overlaps because maybe anti-discrimination law actually challenges the distinction. And I was raised to think that tort law is mainly an issue of corrective justice. I know that some people disagree. And so I think that's why I was thoroughly persuaded by Andrew that the certification is a problem, because it leaves out all the distributive justice aspects of anti-discrimination law that I think in Canadian and in UK law are kind of represented in some sort of way by indirect discrimination. But in the US context, disparate impact discrimination has been gutted by the Supreme Court, besides it already being narrower. So it kind of is left only with the corrective justice aspects. Why am I saying, well, first of all, I was wondering what Andrew thought about that and about whether putting more distributive justice in disparate impact law would help besides all the regulatory solutions, because one interesting thing about the paper is that he brings also public law elements that can better represent distributive justice over corrective justice, besides the private law elements that are focused on corrective justice. But back to your question, that depends on how we define fairness, and how we define fairness, at least from a public law point of view, partly should depend on the historical injustices. So if you are in a context where the base rates are not the same, and the base rates are not the same because one group has been historically treated in a significantly different way than the other, then statistical parity is not the type of fairness that you want. So I think there's a normative conversation about what is accuracy for this particular type of decision. And there's also a normative conversation about what is fairness in this particular type of decision. And in some types of decisions, when you're treating groups that have been treated significantly unequally for hundreds of years, then yes, the normative discussion of fairness could perhaps be, we just don't do this for this group at all.
Can I also jump in? Your question, actually, I thought it was interesting in that what you were pushing back on Ignacio for is essentially an overly individualist version of fairness,
Right.
and you are taking a sort of historical but group fairness more perspective. And so it's this sort of linkage between our papers in a way, right? Like a lot of way we're thinking about fairness in the sort of algorithmic fairness conversation is inherently pretty individualist. Can this model be fair to this particular candidate? Which is something that is informed very much like how we think about discrimination and how the sort of fact community, right, the computer science community thinking about this stuff also thinks about the questions of fairness, because it's about the predictive accuracy or fairness of a particular model as applied to one person. Or a series of one persons, I guess. So I just thought it was interesting. Yeah. I also had a question for Ignacio, but there are other people in mind, so I will wait until the queue is empty.
Hello, Yuma Wu from University of Ottawa. I don't have any substantive feedback for. Oh, this is a question for Ignacio, by the way. I don't have any substantive feedback for these papers. They're very well written. I just wanted to suggest a couple of connections that you might want to make with certain people who are very active in this conversation. If you haven't spoken to them already, I was at CSN Law, ACM CSN Law in Munich, and where Cynthia Dork from Harvard gave a really excellent keynote on this specific subject, and her sort of the main thrust of that keynote on her sort of recent research is on the selection of features and the sort of going to your model multiplicity point, the selection of better features and how to select better features in order to optimize for fairness. And also another author is Ben Green from University of Michigan. I know he's done a lot of work in this area. I hope you get a chance to connect. That's all.
Thank you. Thanks.
All right. Yeah, no, yeah, Ignacio, I've got a question for you. I think you characterized accuracy as something that we have to decide between different versions of accuracy, which to me seemed like the problem was whose ox is gored rather than the sort of inherent incoherence of the concept as a whole. And I wonder, I mean, the way I've been talking about it, these similar issues, is that like even thinking about an accuracy fairness trade-off fails because the concept of accuracy is like, it's not just something we can't like detect or discover, but is conceptually incoherent, right? And in trying to predict something that is unfalsifiable and in the future. And it's incoherent differently for like skin cancer, which you actually can then falsify later, and something like employment, which is inherently unfalsifiable. And so I'm wondering if you have thoughts about that, about like, if it's just that accuracy is conceptually incoherent, or if there's a reason you didn't phrase it that way.
Yeah, no, that's a good point. I'll think more about that. I think it partly depends on the type of decision. I mean, any act of prediction is in some way, one could say, incoherent or imperfect when one tries to measure it in terms of accuracy, because whatever is the counterfactual is something that one cannot observe. And in that sense, the concept of accuracy can be incoherent. But I think it is still true that there's some form of ground truth, even though it's unmeasurable, that most of these predictive exercises care about. So what is incoherent, I would say, is not a general idea of accuracy, but what is incoherent is the idea that we can measure these like unmeasurable social constructs such as, does this person deserve a job? Does this person deserve to get bail? Through the output variables that we're using to measure it. If we were Dworkin's Hercules, we would be able to say whether a decision is accurate or not accurate, because we would be omniscient and we would say, oh yeah, this person will commit a crime in the future because I can predict it, or this person will not commit a crime in the future. Or we would say this person will pay back their loan or will not pay back their loan, or this person will pay their rent or will not pay their rent if we give them this sort of housing. Even though we don't know that. So I think the coherence is in how we choose to approximate it sometimes.
So that's what I wanted to specifically push back on. Is just like the idea that omniscience even can answer this,
right? Hercules himself,
right? Like exactly. Like, and I wonder if it's worth thinking through whether that's actually like, if there's daylight between like inherent immeasurability and the concept not existing at all, right? Is like, I don't know.
I suspect that it depends on the type of decision. Like some types of decisions are specifically formulated in a way that if we had omissions, we would know, like, will this person pay back their loan in 10 years if we give them a loan? Other types of decisions are not, like, does this person deserve this job? Well, what does deservedness mean? Will they be productive? Will they show up on time? And I think there is a separation worth making between maybe those two separate categories.
And it's not just that knowing the future is impossible. It's really that it's the fact of its impossibility proves that you're asking the wrong questions and you're designing systems wrongly, right? Like it's the fact of its impossibility that's the problem. And so that's why I had the same response, imagining the perfect rulemaker knowing the future. Like to purport to do that is to ensure that the future depends upon the past, when really a sort of anti-discrimination norm is trying to push for a future that looks very different than the past that got us here. But we're tethered to it.
And going back to your earlier point that some of these issues are not just AI issues, that is not an AI issue. Having someone decide, do I hire this person? Are they employable? Is someone determining something that is impossible to determine, and they're not predicting, but they're deciding, regardless of whether they use AI or not. Having a judge determine whether someone should stay in or are given bail or parole is also in some way like a determination/predictive exercise, regardless of whether we use AI or not. So some of the interesting things I think about this example is that they show broader problems that go beyond AI about the type of elements that we want to consider when making certain decisions, and when is it appropriate to use prediction as a cognitive exercise, human or AI, for determining the deservedness of someone to get or not get something.
So we don't have any more questions. I was thinking of asking Andrew one more question just about, I mean, since you wrote an American paper and you're an American, we have to ask the question of, like, has anything changed for you recently?
Yeah.
Thinking, I mean, even just the move from something that's sort of common law through the courts to the suggestion that what we could do is something more like the EU AI Act and have regulated, like, how are you?
So let me ask you, did you notice more typos in part 4 than the rest of the paper? I might have had a hasty rewrite. Part 4 was...
You write in order? I'm very
What was that?
impressed. You write in order?
Actually, yeah, I have a hard time thinking outside of order. I mean, I rewrite my introduction, but I have a hard time. But it was written, and part 4 was basically like, the FTC should just take care of this.
Right.
That got rewritten. But like the concept was like, we should turn towards, what I said was actually a consumer protection agency gets rid of a lot of the individual plaintiff difficulties, but I was saying consumer protection agency should actually adopt a product liability model. So what I said instead is like, we could look to these areas of law without specifying, hey, this particular agency. I think, US states would be a place where, and there are a couple of AGs that have expressed some sort of interest in like looking at things this way. And so that if I were to make a prescription, it would be more to go to like state AGs to try to address this. But certainly my thinking on a lot of things has changed. And this paper itself changed from what it originally was. In like 3 months ago.
Okay, perfect. All right, well, unless there are any further last questions or comments, I think we're happy to round up and move on to coffee and cookies. So thank you very much to both of our speakers for 2 wonderful papers, and thank you to everyone here for a wonderful discussion.
Thank you, everyone. Thank you for letting me join you online.
Thank you so much. So we'll just take a really